here.
The Shane's sense of humor is something more and more. We're up next. Okay, welcome back to Senate Education. So S-172, an act relating to education and Bill of Rights for children who are deaf, hard of hearing, or deaf-blind. Senator Hashim has been working on this, and we've asked him for an update. So Senator Hashim, the floor is yours.
Thank you. So I've got several points. I think for any future discussion as we go through the actual language of the bill, we'll probably want to hear from the Board of Education, the Human Rights Commission, and some other folks who've actually had experience, lived experience with these issues. And the reason I mentioned the Human Rights Commission is, this was mentioned in their report, creating this compendium of legislation. And so, hearing from them, and, they also have a jurisdiction over Public Accommodations Act lawsuits. And so I think regarding some of the points I'm going to raise, it might be good to hear from them as to where the gaps do exist in that accountability process. But yeah, so some of the general points, I think from what I'm seeing is, one of the most important issues has to do with accountability and the complaint procedure as it relates to folks who are reaching out to the Agency of Education and going through the process of, trying to make sure that their child is getting the support and help they need. My understanding is that there are a lot of challenges with that, and sometimes the procedure is either confusing or they're not hearing back. And I think that the question I have is how much of that is a legislation issue versus a capacity issue at AOE, or a workforce issue at AOE. And just to clarify, that's not me throwing AOE under the bus.
I understand.
It seems like there's things that are getting lost in the weeds during this complaint procedure.
So just to clarify here, so the young woman from last week, her family filed a complaint, and the Agency of Education, and then something didn't happen, right? Is that
It sounds like that's something that's happened multiple times with
Okay.
different families. There is a list of testimony or stories that I can actually provide to Morgan, we can put it on our page, but different instances of this happening with different families. So
where they're going to the AOE and then something, again, not throwing anybody under the bus, but something's not happening?
there's some sort of disconnect, and there's they're not.
Yeah, you don't happen to know, and I don't remember if we heard this from anyone yet, but AOE, their point person on this, do we know who that would be?
Did she testify? I thought that she
I
testified.
thought we had somebody in
Yeah.
here sitting and right in the corner.
Yeah.
Okay,
Yeah, and then she did testify.
because I think she came up to us afterward and said, hey, I'm gonna look into this. But, okay,
That sounds.
okay.
And then so what else? Another one of the points, focusing on the American Sign Language proficiency, that it should be a prerequisite for teachers who have for deaf and hard of hearing certifications. The teachers who do have that certification should have the ASL proficiency as a prerequisite, and I think again that ties into the need for us to hear from the students who are in these classrooms with these teachers who do want to learn American Sign Language, but just aren't able to because the teacher doesn't have that certification.
Just to clarify, so these are students who may not be of deaf and hard of hearing, but they want to learn ASL, or no?
Not quite, no, it's. No, it's that there are children, that the children who are deaf and hard of hearing. And who have teachers. Who are not sign language certified. Or proficient, just aren't experiencing the opportunity to learn American Sign Language because that teacher doesn't have that certification. And then I think when we get more into, I'm starting to see the patterns here with curriculum and what we do legislate versus what we don't. And I'm seeing that, some of the issues are brought up in the rule series 2360. And actually, or rather they aren't brought up in 2360. And so I think that, well, yeah, no, I don't want to make assumptions about what is or isn't in the rules, because this is why I think we should also hear from the Board of Education regarding the rule series and what is already in law or the rules, because we know that the rules have the force of law. What exists in those rules that is described in the statute, and trying to figure out where the gaps may exist there, and what is trying to be accomplished by trying to change those rules. But we don't. It's my understanding we are not the ones who legislate the rule series. That's the Board of Education, right? So, and I think that the like the IDEA, we can. Sorry. We can create similar analogs, you can call them, that mirror federal law and have them be in state law as well, as an enforceable set of rules or set of statutes. And that, I want to double check the language in the bill itself as it relates to whether or not we are recreating those federal statutes, or if we're simply saying that different schools have to follow those federal statutes. It's not 100. It's not quite clear with the language, but that's St. James' question. I think so. Yeah. So that's what those are my initial thoughts. And just to close, I think, again, that Board of Education, Human Rights Commission, and a couple more folks with lived experience of going through this process to figure out where the cracks are. And, again, the Human Rights Commission, this was one of their recommendations. And so hearing, Amanda Garces was, I think, supposed to submit testimony. I asked her if she would be available today, and she's not, but following up with her. And
She's Christian, or she is.
Yeah.
Okay.
So I think following up with her to hear from that organization as to what they're seeing as the gaps as well, I think could be helpful.
Okay.
Yeah.
So we're looking to understand where some of the gaps are. So we'll have Amanda Garces in. And do you think the State Board of Education will be helpful in terms of understanding the gaps? I mean, they might be, or just.
Yeah, I mean, there are some
Not sure.
recommendations that I think would go into the rule series rather than legislation.
Okay.
And I mean, if it's a request that we send to the board to, make some changes, I'm not sure how that rulemaking process goes, or rather if it's a group of citizens who have to petition the Board of Education to make those rule changes. I guess that's the remaining question.
So would you, if we had, I think the person who can probably answer that best might not be a state board member, but Emily Simmons, AOE's Ledge Council, and I think she also supports the state board. Have her Zoom in and we can ask her that question around rulemaking. And then Amanda Garces can come in.
Yeah.
And then you can provide us some more information from families around, again, the gaps that you're seeing, that they're
Yeah.
seeing out there.
Yeah, I have a document that I can provide to Morgan, I can share with everybody. They did also send a petition over that includes 75 Vermont residents. And from what I can gather from the chart, I believe the second or third highest listed issue, or, the question was, why do you support this bill? And as far as I can tell, it's either the second or the third highest reason is because, quote, the educational system does not sufficiently accommodate the needs of deaf and hard of hearing and deafblind children. With number one being, this is a human rights issue.
Yeah, and I'd still like to understand, and we can always talk to them on or offline, what sort of happened if parents are reaching out to AOE. It sounds to me like they might need to streamline
The
something.
interpreter, just double checking, what was the number one reason that you said?
The number one reason, this is a human rights issue.
Thank you.
Thanks for asking.
And also just for transparency, the total number of responses were 108. 75 were Vermont residents and 33 were outside of Vermont. So I'm not sure from where, but that's what else provided.
Yeah, okay. So for you, next step, Emily Simmons, Human Rights Commission, and some students or some families. Yeah, that's really okay.
I think that makes sense.
Yeah, I understand where the gaps are.
Yeah, and I also want to add for what I think would end up being included in the rule series are the more cultural and curriculum, the requests that are related more so to culture and curriculum, which I think would go into the rule series rather than law.
And you had mentioned, I think, that Maine had done this.
Yeah, Maine and also New Hampshire. I think there were, I think it was 18 states in total.
What was the big pushback last week or the week before on this? We heard
I think it was 2 weeks ago now. I think we heard that it was redundant and that, these laws are already in place. But then when we look at the testimony of the kids and their parents, there's clearly a disconnect because the people who these laws are meant to protect and accommodate are not experiencing that protection and accommodations from those laws based on the situations that they're describing.
And do we know from Beth St. James, did she say it was redundant? Perfect timing. Senator Bueller, please, you had a question. Ms. St. James, please join us at the table.
Sure. I was just, I think I said echo pretty much what you were saying, which is, can we find out if it is in law? And because it does seem as though we've come across this issue before where something's in law, but it's not being done. And what's the responsibility of the AOE in making sure that it's getting done? Like, there just seems to be a lot of confusion around that. It'd be nice to
know who that point person is in AOE, and I think we met her, but I don't remember her name. We're talking about S-171, Senator Hutchins' bill, please, Senator Williams. Oh, sorry.
Well, 172,
Yeah, thank you.
So, and I've asked this question before, and I don't want to belabor the point, but if it's happening to deaf, hard of hearing and deaf blind people,
Yeah.
is it happening to blind people too? And I know that that's not your constituents' focus, but if we're going to talk about mandates that apply to that group, are the blind people have the same problem?
I think I think that was raised 2 weeks ago, and the answer, as best as I can remember, has to do with the fact that folks who are in the deaf and hard of hearing and deafblind community, have their own culture, have their own language, and unlike what you see with folks who are blind, I do think I wouldn't be surprised if there's overlap in the issue regarding the accountability piece and the complaint procedures, but I think that, the second component of this bill regarding culture and curriculum, I don't think that overlaps with the blind piece. So, yeah, does that,
Yeah, I'm just concerned from an equity standpoint. That if we're gonna be mandating it for one group, we should be making sure that everybody's covered.
Yeah, and if you don't mind, just putting a mental note
Yeah.
as we go forward, and we'll be folks after that.
Thank you.
Ms. St. James, if you don't mind, before we get started on what we have you in for, which is 191, 172. We have a question. We heard that the language in 172, I think we heard it from the agency of food, so is redundant, that it's not needed. And I kind of remember you being in the chair and answering this already, but would you mind helping us out?
Sure, Beth St. James, Office of Legislative Counsel. So I am not able to speak to whether the entire bill is redundant or not, but
Okay.
generally speaking, if a student qualifies for special education services either under IDEA or Section 504 of the Rehabilitation Act of 1973, many, if not all of these components may be a part of a 504 plan or an IEP. The federal special education laws require students to be provided with a free, appropriate, it's FAPE, and I always haven't been in the education world long enough to remember FAPE. It's probably not a great free and appropriate public education in the least restrictive environment. So it's possible that in order to provide a child with a free and appropriate education in the least restrictive environment, school districts are already required to offer many of these services. Now, if a student does not qualify for an IEP or Section 504 plan, there are other non-federal components to special education provisions, and also supports in the general classroom. I'm thinking multi-tiered systems of support. Act 173, even creating that new definition of students who are needing additional support, which would be outside of the special education context as far as IDEA and Section 504. So I am not qualified to sit down and say, okay, subdivision 4 is automatically provided for under IDEA or Section 504, or it would be a requirement under, tier 2 supports and multi-tiered system support. But my guess is if you're hearing that this bill is redundant, that is part of it, is that if a student qualifies for any extra support, it's possible that all of these supports would already be provided. It's possible. I'm not saying that this, and there could be a population of students who would qualify for supports under this bill very specifically, that would not qualify under Section 504 or IDEA.
Okay.
Or perhaps they would qualify for extra support in the general classroom setting, but maybe if not all of these items are required, maybe not all of them would be offered. So I think there's
That's helpful.
potential for overlap and
Yeah.
also some non-overlap.
So we've asked we're gonna ask Ms. Garces to come in to help us understand the gaps that she's hearing next week, and we're also gonna hear from Emily seconds to see if she wants to weigh in or ask her about homemaking and she might be able to.
She might, have you heard from someone from the special education department?
I believe that's who we had in
Okay.
last week, but I'll
Okay.
check with Morgan. Yeah,
And as with,
yeah, Ms., I can't remember her name. I don't wanna say what, yeah,
I just emailed to try to find out.
and as with anything, you know,
it's not,
whether you're, how you ask questions sometimes makes or breaks whether you get the information that you need, right? So if you want to know if everything in this bill would be provided for someone who qualified for services under IDEA or section 504, you have to ask specifically, would subdivision 6 be part of an IEP or a 504 plan if a student was deafblind or hard of hearing, and just saying generally, it's redundant.
right. just-
Like, what does that
yeah,
mean?
What does that mean?
Yeah.
Yeah. Sarah, Porcello. Porcello. Was that her name?
Coachella.
Meg Porcello.
Oh,
Yeah.
okay.
Sorry.
I'll hold my question for now, I think. Yeah, I'll hold it.
Okay.
But thank you.
She did submit 5 pages of testimony.
So, anything else on 172 at this point? Sounds like we're working away on it for once, yeah. Now we'll shift to 191. Thanks, Sarah. Anything else from your end?
No, I'm good. I think, thank you, Beth, for the note. I think. I think one piece is making sure that this applies to not just deaf students, but also hard of hearing and deaf-blind students. I think that is one of that might be one of the gaps. And I'm gonna have to rewatch the testimony, but it was 2 weeks ago now, but.
And I'll
Yeah.
try to rewatch them it also. And would you, in the bill, just unless Senator Sheep objects, Senator Williams has raised issues of people who are blind. I just want to lose sight of that. If you could just make a note somewhere.
Sure, the bill is very specific about services for one particular group
Alright.
of people. So I would need a lot of direction on.
All right, why don't we hold off
This
for
would
now?
be
But yeah,
required.
yeah, okay. I just don't want to lose that request and question. Okay. 191, an act relating to New American Advancement Grant applicants. And we have a revised version, I believe, after we heard from Tom Little from BSAC. So. And so I think we'll go ahead then, Ms. St. James, if you want to take us through the changes.
Sure, Beth St. James, Office of Legislative Counsel, you should have a potential amendment, draft 1.1 to S 191. So this would be the first change to the bill that you've seen since the bill was introduced. And this is based solely on feedback and suggestions from Tom Little from VSAC's General Counsel. So the bill on page 1, subsection D, the changes are highlighted in yellow. So notwithstanding subsection A of this section, which is talking about who qualifies for an advancement grant. So it would be the term resident is what we're really focused on here. Applicants who qualify for in-state tuition to the Community College of Vermont pursuant to subsection 2185C of this section shall not be ineligible for the advancement grant solely on account of the applicant's residency status. So if they haven't been here for a year, if that's the only reason they would be ineligible, that non-year residency piece would not make them ineligible. If they're not eligible for other reasons, this does not this does not automatically qualify them for an advancement grant. And we're gonna talk about who them is in a second, but that in is not ineligible. I know that's not the most elegant writing, but it's basically saying if you meet every other requirement, but you haven't been here a year, you're eligible. Okay, so who's eligible? So in 2022, the legislature passed an amendment to the determination of residency for tuition purposes for the Vermont state colleges, specifically the Community College of Vermont. And so that language says, for determination of residency for tuition to Community College of Vermont, a person who resides in Vermont shall be considered a resident for in-state tuition beginning at the start of the next semester if that person, and then this is the category of folks that would qualify for this advancement grant. If they haven't been here for a year, but they meet all the other eligibility requirements. So someone who qualifies as a refugee pursuant to the federal definition of a refugee. Someone who has been granted parole to enter the United States pursuant to, I believe this is the humanitarian parole federal definition. Or is issued a special immigrant visa pursuant to the Afghan Allies Protection Act of 2009. So if an individual met all of the other advancement grant eligibility requirements and fell into one of those categories, if they hadn't been here for a year, they could still qualify for an advancement grant. That 1 year residency piece would not kick them out of eligibility, exclude them, yes. And then, so the bill is introduced. It was the same concept to a much broader category of people. It listed just several immigration statuses. But section.
Can I interrupt you real quick? What I'm not seeing, the language in the bill is introduced, on. So this section D here, am I blind or is it not in this potential amendment?
It is. So this amendment is changing that language,
Okay,
right? We're amending the bill as introduced.
so in 2185.
So the language that's highlighted
Yeah.
is new.
Right,
So what,
and it's cross-referencing 2185, which
is what I just walked us through,
Okay,
which are those immigration statuses.
thank you.
Okay. Does that make sense?
It makes total
Okay.
sense. Thank you for clarifying.
And again, that was a recommendation from VSAC. So I think that works completely for legal reasons. My advice to you all would be, my question to you all would be, are those the communities that you want to, meet with this language? Because it's, as I think I've mentioned, like, especially when we're talking about, everyone uses the term Afghan refugees, but many of them are actually here under humanitarian parole, right? So when we're throwing around these different immigration statuses that none of us are qualified to really understand, right? I would just want to make sure that you all know who you are impacting with this legislation. And so if you're comfortable with this language, great. If you're not, if you're concerned that you're leaving someone out or you are including a community that you don't need to include, let's figure out the right people
Do you
to,
have a copy of that here? Or you just referenced?
what?
Of the,
of section
cross-section?
21. No, but I can send it to Morgan.
Yeah, that would be
Did I
great.
send that to you, Morgan? No?
I don't think so.
Okay.
And do you mind just reading over capturing this? So I
Yes.
hear it more time, thanks. And
So-
if you don't mind printing up 5 copies, that'd be great.
Someone who qualifies as a refugee pursuant to the federal definition of a refugee.
Yeah.
Humanitarian parolees. And someone who has been issued a special immigrant visa pursuant to the Afghan Allies Protection Act of 2009 as amended. And then,
Anybody have any questions on that? get it printed up and I'm going to pull up the note I have showing fiscal ones. Please go ahead.
And then, this was not in the bill as introduced, but was a recommendation of VSAC, so I've included it for you all to consider. Page 2, adding a brand new section, incentive grant eligibility. So section 1, and the bill as introduced was only for advancement grants. Section 2 would be a change to eligibility for incentive grants, and I'm pulling up incentive grants. So I can read to you, they are a need-based grant program to aid students who need financial assistance and are pursuing undergraduate studies and give promise of completing satisfactorily a degree program or who have been accepted for admission to an approved post-secondary education institution for undergraduate studies. So remember, advancement grants are for I don't want to get it wrong. Non-degree education, and incentive grants contemplate that you are seeking a degree. Right, it says it right in there, completing that promise of completing satisfactorily a degree program. So section 2 is making essentially the same change to eligibility requirements. Incentive grants also have a 1-year residency requirement, as does the residency requirement comes from the definition of resident for all of VSAC's programs in this title, or in this chapter. So notwithstanding any provision of law to the contrary, a person who qualifies for in-state tuition to CCV pursuant to the language we just walked through, so refugees, humanitarian parolees, and Afghan Allies Protection Act, special immigrant visa holders, shall not be ineligible for the Vermont Incentive Grant Program solely on account of that person's residency status. So again, making that same residency exception for the incentive grant. The big difference here is that what VSAC is proposing is that this is a temporary, the section 1 would be amending the green books. So the thought there is that it's in perpetuity until you change it all. Section 2 is a piece of session law with a repeal date built in, so 3 years from now. This language actually appeared in the same bill that amended the CCV in-state tuition language as a piece of session law for 1 year. It was repealed, I believe, or 2 years, it was repealed July 1, 2023, I believe. So my understanding is that VSAC is recommending that we try this again for 3 more years.
So this is already in law, you said? Or-
No, it ran out,
It
it
ran
was
out.
repealed on July 1, 2023. So just
Got it.
past July,
Okay.
Just to continue it.
for until July 1, 2027.
Yeah.
Or, whatever date you all pick.
So this would just be going back to the way it was. Just
For that
half
1
a
year.
ago. Yeah.
For that 1 year,
Yeah.
from July 1, 2022 to July 1, 2023. Yes.
And I heard back from Ms. Richter, she doesn't see a fiscal impact. When she doesn't see S-191 as having a fiscal impact, and I think it's probably because, and I'll go back and confirm this with folks, that the dollars are coming from dollars that have already been appropriated or will be appropriated to VSAC itself. So I think what Tom said, I could be wrong, that their budget can withstand this additional request, these additional hits, if you will, that I'll go back and confirm. Yeah.
It's kind of an odd perspective. That is a fiscal impact, because if the money weren't used, the money would roll back and just become liquid for some other.
So I have her email, I'll forward it along to everybody, or have Morgan print it out. So we won't be we can always have her, we won't be allocating, appropriating more money because of this.
That I get.
So we'll take his budget, which has already been, either last year's budget or this year's budget, and pull from that. And I think, and I could be wrong, we can have her in, I think it's a good idea to talk about this. When she says there's no expected fiscal impact on S-191, therefore no formal fiscal note is required. I wonder if she sort of interprets that because we are not going to appropriate a certain amount specific to that. So we can, we can Right. Yeah.
Those are the changes to the bill as introduced.
Yeah, please.
So to your comment about no one here being really qualified to fully explain or dissect the status of immediate refugee, et cetera.
Oh, no, that's not what I meant. I meant every immigration status and who qualifies under that immigration status.
Okay, so how do we, right, but how do we, so I understand how humanitarian parolee is Christian. The Afghan issue, I understand. But the refugee status, my understanding, again, I'm not an immigration lawyer, but it's a rather broad characterization and incorporates political refugee, economic refugee, et cetera, natural disaster refugee. I mean, we do need to understand that before we can really decide if this is an appropriate use of state treasurer.
I can read you the definition.
Okay,
I'm pulling it up right now. And forgive me if my comment was, not helpful. I meant is you all are trying to determine what categories, what communities you are trying to serve with this language. There are many immigration statuses and immigration statuses within immigration statuses. So just saying, there are folks from X country in my community, and I want to make sure that they are served, we would need to figure out what is their immigration status. And that's not something that I'm qualified to figure out. We would need to talk to those communities. So let's see, the federal definition of immigration is,
immigration or refugee?
I'm sorry, refugee. Any person who is outside any country of such person's nationality, or in the case of a person having no nationality, is outside any country in which such persons last habitually resided, and who is unable or unwilling to return to, and is unable or unwilling to avail him or herself of the protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group or political opinion. That was A. Or in such special circumstances as the president, after appropriate consultation, may specify, any person who is within the country of such person's nationality, or in the case of a person having no nationality, within the country in which such person is habitually residing, and who is persecuted or has well-founded fear. So that's outside of their country or in their country. The term refugee does not include any person who is ordered, incited, assisted, or otherwise participated in the persecution of any person on account of race, religion, nationality, membership in a particular social group or political opinion. And I think there's some more to it, but I think for the purposes of I can send this. I'll send this to Morgan to post. But yes, that is a broad definition.
It also takes some time to actually get refugee status, and then, I mean, my understanding is that you show up to our country seeking asylum, you're an asylum seeker. And then you have to go through a process that involves court to get that refugee status. And I think maybe I'd follow up with an immigration attorney for that, but that's my recollection.
Yeah, so I think you're kind of hitting on what I'm trying to highlight for you. Asylum seekers or asylees would not be, I don't believe, included in the carve out here. And so that's why figuring out the communities you want to be serving with this language is so important, because the constituents that came to you or the constituents that you were working with may not be affected by this thing. I don't know who they were, right? But yes. And I had, when I was drafting the language for the Community College of Vermont, I believe I had been in touch with someone at Vermont Law School, who worked in the immigration clinic there, who helped me. So I could find their name perhaps. And either reach out or put you in touch or have them testify, but. If you know anecdotally, these are the people in my community or a community that, and here's their immigration status. I can trace that back and try and find some language for you. But I'm not gonna be able to come up with every immigration status that's here in Vermont, right?
I do know an immigration lawyer in Burlington. I could pick his brain for a little bit, or even have him testify. Or the person who Beth mentioned.
There's one of Roberts, isn't
So for this bill, right now, the main witness I have coming back in is Julia Richter to sort of talk us through the possible financial impacts. Anybody else want to hear from somebody? Do you want to hear from a particular immigration attorney on this? Or do you want us?
I mean, I could. It could, well, I guess that'd be up to the rest of the committee. If you want to hear from an immigration attorney who I'm sure he'd be willing to testify. I don't want to assume for him, but I'm sure he'd be willing to. He's worked with Afghan refugees and would be able to clarify the process that, you know, you don't have refugee status the second you show up here. You know, you have asylum seeker status and you have to go through this court procedure to actually be granted refugee status, but that's not an area that I have expertise in, and I want to confirm or clarify that. So if, yeah.
But I think it would be a good use of, 10 minutes of Zoom time, just to kind of,
Make sure we get all
can't make a decision based on what we think it.
Yeah.
Is he gonna charge us?
I'm fine with that. Well, that's,
Is he gonna charge us?
I didn't ask him here.
Pro.
His name?
Yeah.
You
I'd have to double check.
Okay.
My email.
Anybody want to hear from anyone else in addition to the attorney and Julia Richter on this, or any red flags? Anything else on this?
So
Yeah, please.
going back to your earlier comment, I think Julia would be, or someone who would be able to quantify this. I know that there's money to potentially scrape up to get that, but what is the?
I think Scott would be able to answer.
Scott Giles
CFO.
will probably be able to, because the VSAC guy, we could ask Scott just to, how much we're looking at from his
Your
budget.
CFO might
Yeah,
have, or I guess,
yeah, no, it's a good point. Yeah, but he's thinking,
Chief Financial Officer.
Chief Financial.
for DSEC, yeah.
Otherwise, I think we're pretty good. Yeah, so we'll see what they're thinking. Because they must be anticipating some number, and they can't be anticipating, I'm guessing they're not anticipating 1,000, but where are they getting their 100 or 20?
I think it would honestly just be a couple dozen.
Yeah. Maybe we'll talk about that. Set. Great. Beautiful. Okay, the St. James,
Are we moving on?
171. Unless you have any other comments around this.
No, do you have any homework for me on this? Bill?
I don't think so. I think we'll have Senator Hashim will set up the immigration attorney. We have Julia Richter, Morgan will set up for next week, as well as the CFO from BSAC, dig up that person or their designee and go from there. And then I think we'll be ready to roll. Yeah, please.
Just for your information, Dr. Levine's testimony is on the website.
Oh, thank you. Oh, that was
Thank you, Mark.
fast. That is fast. Great. Terrific. So S-171, this is Senator Ron Hinsdale's an act relating to legal residency of a student following displacement by natural disaster. We're going to look at a few definitions. We asked you to do that. And wondering, I think you have put a whole thing in our files. If you wouldn't mind filling us in.
Sure, Beth St. James, Office of Legislative Counsel. My charge for today was to help come back with some information, some potential definitions, anything I could find out there for natural disaster and displacement. And it's not good news.
Okay.
Um,
And just to remind everyone, one of you were a lot smarter than I am. What was it, McKinney-Venti?
McKinney-Vento
Vento, okay.
for homeless students.
Home
So
students, yes.
remember, this bill proposes to add a section to section 1075 of Title 16,
Uh-huh,
which is the legal residency statute for how we figure out what school district a kiddo belongs to. Okay. And generally speaking, we figure that out by looking at where the legal guardians are residing. So if the legal guardians of a child are residing, they're domiciled in a school district.
Yeah.
That's where that child goes.
Yeah.
The statute also has provisions for state-placed students, so students that are in state custody for CHIMS cases.
okay.
That's just one example.
So just continuing that thought, so if somebody's been removed from their home.
Correct.
The
And they-
Florida statute dealing
them.
with where the foster home is.
Exactly.
He or she may
Exactly.
return to that
Exactly.
school for unlimited period of time? Or until-
I don't know off the top of my
Okay,
head.
that's
I
fine,
would have
probably
to-
until the fostering program is over, maybe.
I would have to
That's okay.
read the statute there, but, the statute also has a provision for how we figure out the resident status, so what school district a homeless student belongs to.
Okay.
And that's where the McKinney-Vento Act, which is federal legislation, comes into play. And McKinney-Vento touches on many different things for secondary down, so not post-secondary, it's for public school. So social services, all kinds of things, schools are required to have a McKinney-Vento outreach coordinator, right? There's like all kinds of requirements. But one of the requirements in McKinney-Vento talks about access to education for homeless students, right? So, and there's a whole bunch of, and I'm not the expert, you had I watched the testimony you took from the folks from AOE about McKinney-Vento, so I am not an expert in that piece of law. But their presentation was very clear on the services and the rights that are afforded children that qualify as homeless under that federal legislation. For state residency purposes, for how you figure out if a student, what school district a student goes to, this statute provides that the legal residence or residence of a child of homeless parents is the child's school of origin, which is what I believe this bill is trying to get at, right? Unless the parents in another school district agree that the child's attendance in school in that school district will be in the best interest of the child. So, if it's better for the child to attend the new school, then great. But a child of homeless parents is defined as a child whose parents lack a fixed, regular, and adequate residence, or they're currently living in some sort of shelter or temporary accommodation, such as like a hotel for on a public assistance voucher. So I think the conversation you all had and the caution that you were given, I think slightly in my walkthrough, but certainly in the testimony that you took from AOE, was that it's possible that many children who are, I'm gonna use air quotes here, displaced by a natural disaster would fit in this homeless category.
Yep.
And so there's already a piece of law
Thank you.
that would govern them, okay? But the gray area is, what is a natural disaster? And what does displacement mean? Because it's possible that what you all are thinking of as far as displacement may not mean that someone lacks a fixed, regular, or adequate residence.
Okay. Senator Weeks.
I recall though that the fundamental problem was that a family who may be displaced from their original domicile, they take up a temporary domicile, they then are not homeless because they have.
Yes, that's exactly the point I'm trying to make. So depending on the population you are trying to reach, or the set of circumstances that you are trying to take into account. If, let's say a student lives with their family in one school district and their home is flooded and it's not habitable and they have to move.
Yeah.
But the family has the means to rent a new house, buy a new house, et cetera, in a new school district. There's a possibility that that student would not meet the definition of a homeless student, right? So
Right.
there would be no law that automatically entitles them to stay in the old school district. That's what this bill could do.
Right. That being said, is it possible that family could petition the school board and say, hey, this is really important to us. Sure, we were able to afford a house here, but we really want Sarah to finish the school year or something like that.
Yes, it's a little more clear for high school, a little less clear for elementary school, and
Okay.
so to look at that set of circumstances, we're gonna jump to chapter 21, which is the maintenance of public schools, which is the town tuition program, which is where we talk about the requirement for schools to maintain an elementary or high school or pay tuition. So for elementary schools, which is grades pre-kindergarten through 6. Let's see, what does it say here?
Talking about if kids get, not you get displaced, but they're able to afford a new house somewhere and they still want their kid to go to that school, could they petition their school board?
So the elementary school
Yeah,
says, you gotta maintain a school or provide, or pay tuition, right?
yeah,
Notwithstanding those options. If a school board in a district that operates a school board in district that operates an elementary school may pay tuition for elementary students who reside near a public elementary school in an adjacent district. If it's within the best judgment of the, if it's within the best interest of the student and the judgment is left up to the school board. So that's very narrow for elementary school. For high school, it's different. For high school, the statute that requires the school district, if they are organized to provide high school education, they've either got to maintain a high school or pay tuition. But it also authorizes, bear with me. Just looked at this to prepare for today. Okay, a school district may maintain a high school, both a high school and French high school education by paying tuition to a public school as in the judgment of the school board may best serve the interests of the students. Or at an approved independent school, if the school board judges that a student has unique educational needs that cannot be served within the district or at a nearby school, and the judgment of the board is final. So for elementary school, the only discretion for a school board is if you're border of another school district.
Okay.
But for high school, it's any public school or any approved independent school that's in the best interest of the children.
but if a family gets displaced in their child's 3rd grade, they have to then use the school that borders their other school.
No, if a
3rd grader's displaced.
if a 3rd grader is displaced, we
Yeah.
haven't really determined what that means yet, but we'll just use the example of they can't live in the home that they were living in, right? Current law allows for their. Well, it depends. They might meet the definition of homeless, in which case they would be able to stay in their school of origin.
Yeah, right.
If they don't meet the definition of homeless, I think they could still petition their school board. It would depend on, I guess if they don't meet the definition of homeless, then they probably are a resident of the new school district, considered a resident of this new school district. And if they were in 3rd grade and you were a resident of the new school district, you could petition that new school board and you were on the border of your old school board or school district, you could petition to go to the old school district. The school district does not have to say yes. But also, within the legal residency statute, if there is a dispute about residency, the secretary makes a final decision. In fact, any interested person or taxpayer who is dissatisfied with the decision of the school board as to the student's legal residency may appeal to the secretary.
So there are a lot of avenues
Yeah.
here,
Yeah.
but may I ask one question? And I'm sure I'm missing something. What if this committee were just to say, given, I think Senator Chittenden's bill and Senator Rompuzdale's bill, what if we were to say, no matter what your circumstance, your family's transferred or you buy a new house or anything, that you can finish that one school year? So what am I, 'cause I'm looking at the committee.
It seems like you could though, with a petition to the Secretary of Ed.
Well, it's contingent upon
No, I think-
given the okay, right, the green light?
Yeah, so there, you could petition your school board and the school board could say, great.
Yeah, but they could say no.
Or they could say no, you could petition, this, and so that's for paying tuition. If it's a town that maintains a school district. Or operates school. If the town is a tuitioning town. That piece of law that we just walked through would not apply. That law doesn't say if you're a tuitioning town. I mean, if you're a tuitioning town, you get to go wherever you want anyway. If you lived in an operating district.
I guess for me, I'm just interested, if some child, it's January. Wherever they're going to school, that they can just stay at that school and just wrap things up. If that just feels right to them and their family. Senator Hewitt.
I was just gonna suggest maybe we could hear from some superintendents, because now that we're talking about this, I know it's come before.
I know, it had, right,
Come before the school board that I serve on, and I know that we've had these discussions before, and I feel like there's oftentimes, at least within like maybe even the county. I think superintendents work with each other to make sure that,
Generally, this kind of thing works out.
yeah, I think so.
So if the elementary school language is the least restricted,
It's the most restrictive right now.
okay, so how about if we just
Mirror the
change the language to the one that's
least restrictive.
right? And
That's
make
right.
the other one the same.
That-
Require change of statute.
So, yes, everything you guys
Yeah,
do likely
yeah,
requires
right.
a change of statute,
Okay.
that language is specific to bordering, so that would only work. If the district that you move into bordered your district of origin or your school of origin.
But I think what the Senator Williams is saying, I could be, you might be saying the same thing, is if we were to make the elementary program, the language mirror the 9 through 12 language.
Oh, that's not what I heard him say, but sure, you could do that.
Because that makes them both equal and maybe gives people a little more flexibility
You
in
could
that.
certainly do that, again, it's discretionary with the
Yeah.
school board, you
We'll
know.
hear from, yeah, I think it's a good idea, we should hear from school boards and the superintendent's association on this and see what people think. I mean, for me, it just seems like for a kid to have to make new friends middle of the year rather than the new year.
So then I would,
I
so,
wasn't the most popular kid in town, so sometimes it was trouble if I was in, if it was September or January.
so I would encourage you to think about how long,
Yeah.
sounds like you're circling, just finishing the school year.
Sure,
And
yeah,
then,
yeah,
transportation is not required,
that was part, yeah,
period, right? That's discretionary for school districts. So if you live in a school district with a transportation, policy, and you're staying in the school district, but you've moved out of school district, how does transportation factor into that? I believe there's already some language, somewhere that we might be able to draw on, but you could certainly say, you could either make transportation discretionary in school districts and let the school district decide if they're gonna provide transportation if they do for everyone else. You could say, under no circumstances, it's the parent's responsibility if they're taking advantage of this provision. you know, or, you know, we can craft something.
Kind of lost track of it for a second. Are you referring to any family that decides to move during the year that they would be allowed to finish the school year,
Yeah.
or displaced families?
Well, I'm just thinking maybe the cleanest way to do it, the easiest, is if, no matter what their circumstance, if they want their child to finish their academic year there. And transportation, you know, they're gonna do the transportation, everything. Probably talking 10 kids, I don't know, we can ask the Superintendent's Association. But it seems to me like it'd be a good thing for the kid.
Especially if they're already paid the property taxes there.
No, I'm just thinking,
Sure.
yeah, but. You can have them come in and. I mean, it gets rid of the whole, what's a disaster, or it's not a natural disaster, you think, you know, that sort of thing. But. We can hear from folks. Please, go ahead.
No, I was just thinking about how tuition factors into all of this, but if it's just for finishing the school year, maybe that's not.
And we wanted to stay at that same school, this
Right.
isn't like, okay,
Right, but I'm just thinking of the family that moves into an operating town out of a tuitioning district, right? If it's just one school year, they could
Yeah.
remain in that potentially approved independent school. But if you were to go if you were to go, let's say till graduation or something like that, you
okay,
would be having folks who are moving into an operating school district. Allowed to tuition to the school of their choice,
right,
just because their family decided to move.
Right.
Into an operating school district.
I don't think I've seen the time.
yeah, so you're saying if somebody is in a non-operating district. And they move to an no, you're saying if they're in an operating,
And they move to if they're in a non-operating district
yeah,
and they move to an operating district.
yes,
This bill would allow them to continue receiving tuition. Or
Right.
this idea
yeah,
would allow them to continue to receive tuition until however long you all decide. And so I could imagine different math depending on how long.
But-
Literally math as far as cost, right?
yeah,
You know,
but would you be, yeah, if we were to let it go on and on and on and on.
yeah, I mean, there could
I
be
think
more of a
finish the
fiscal
school year.
impact
Yeah.
with that versus, finishing the school year.
Okay.
But that's a policy decision, so
Right, no, but I think,
perfectly
again,
legal.
just speaking for myself, the family wants their kid to finish the school. A couple months there, whatever, hate to see this huge process have to happen where they're petitioning people and everything, but. If it generally works out. Keep it as is, but, okay. Anything else on this?
No, I will just note that there is no definition for natural
Right, and that's where this
disaster.
sort of maybe means that, gets that done a little bit more easily. Yeah, I love that.
Any homework for me on this bill?
No, I'm gonna ask Morgan to ask the Superintendent's Association, the School Board Association, here you go, Morgan, you can ask them that question. So I'll be in next week and hopefully, and I'll talk to Senator Lumpkin still.
I could see if you're in high school and you're like a junior and playing sports and,
Totally,
yeah.
completely, yeah.
If you're in elementary school, it's not such a big deal. Bring it over.
But you have your little buddies or whatever, and yeah,
Just comment that, often families make, job decisions that affect where they live and where they work, and affects where they live, where they go to school, and those are decisions that families make all the time, and I'm not sure that, I understand the displacement and natural disaster, but to then shift more towards, kind of softer approach to pick your job and, pick your school, it's kind of collateral support by this legislation.
tell me a little bit more about what you mean.
So which part? Because
Well, so if you, so this scenario where all of a sudden a kid's in 10th grade and the parents are moving 4 miles away, but it puts him or her in this new district. If the committee wanted to move in this direction, he or she could stay at that original district until January, until the end of the school year. Tell me a little bit more about the concern.
well, I just, I understand the premise,
Yeah,
but I also understand that, parents are making decisions all the time about
sure.
following the job, essentially following money. And, just not sure that, those kinds of decisions, need to be reflected in legislation to basically, place their kids.
Common benefits.
Yeah, the benefit is for the family, not for the community. So I'm just ambivalent about it,
Yeah, no, yeah,
as a kid, a military kid.
yeah,
I did probably 3 schools where it was halfway through the year.
yeah,
It's not a crisis. Benefit is you're shifting into your new location earlier rather than lingering and waiting. It's just a different perspective.
that's a really good point also. Fair enough. Yeah, I mean, the parents could also say, come on, Sally, you're coming with us. If they thought that was best completely. Yeah, that's a good point.
So anyway, I'm listening. I'm not.
Yeah.
Natural disaster bid, yeah, that's got some relevance.
Yeah,
Okay, I get that, but broadening it out, to 2
yeah,
extra.
yeah, absolutely.
And
Yeah.
we'd like to leave Senator Grant Hinsfield happy too. That's for
She'll
sure.
appreciate that. Yeah. All right, why don't we take 5 minutes until our folks from the school board from the, we have one more,
It's a marathon.
Oh, we're
That's it. We've got-
gonna take this.
well, that's 303. We have just a brief testimony. This is
Thanks, Bill.
Hey,